next matter to come before the court this morning, is all parties here? Mr. Murphy and Mr. Whiteman.
Yes.
Mr. Whiteman, is State of Ohio versus Nathaniel Allgood. Again, each party will have 15 minutes which to present the case. If the appellant wishes to retain some of that time for rebuttal, let me know when you come up to the podium. I'm keeping track of the clock and I'll keep you at time. We are being visually and audibly recorded online, so please try to remain by the podium as much as possible. We have your briefs and are ready to proceed when you are.
Thank you, Your Honors. May it please the court, my name is Dan Whiteman. I represent Mr. Nathaniel Allgood. Mr. Allgood is a 58-year-old gentleman. He is currently incarcerated in the state penitentiary in Southern Ohio. He has been jailed in regard to this charge, in regard to these cases, since January of 2017. Now, I know the court's read the briefs, and our primary issue here is whether there was sufficient evidence to convict Mr. Allgood of this charge of attempted rape. And luckily, the record is relatively short in this case. There's not a lot of testimony, there's not a lot of evidence pertaining to the facts, pertaining to the facts presented by the prosecutor to prove this case. And I think I've made a reasonable attempt to set those facts out in my brief. Essentially, Mr. Allgood was at the home of his daughter and his 2-year-old grandson. He apparently was intoxicated. Sometime later in the afternoon, the child's father came home, and the mother and the father of the child both fell asleep. And sometime later, the father came downstairs and found Mr. Allgood in the bathroom with the 2-year-old grandson.
Was that after you heard him say something like, hug me some more?
It was after, but we're not sure. I can't recall the amount of
But there was
time.
something.
There was something
Statement
like,
like
give me a good hug or something to that effect, correct. So anyway, Mr. Sims comes downstairs. He's looking for his son. He's looking for Mr. Allgood. There's a single bathroom in this apartment. This is a relatively small apartment. The bathroom door is open, and he's able to see through the crack of the door. And he testified that he observed his son with his pull-up diaper down, standing next to Mr. Allgood in front of the toilet. Mr. Allgood had his left hand on his son's shoulder, his 2-year-old son's shoulder, and he was putting his own penis back into his pants when he came in.
Counsel, because neither of your briefs made it clear in my head, can you tell me when father walked in, was the child facing the toilet or facing grandpa?
That's a really interesting question. I have argued he was facing the toilet in this particular case based on what I read in the record. I think that is the way I read it.
Okay, thank you.
Okay. I did not handle the case at the trial level.
I appreciate that.
I'm not positively certain about that, but the facts indicate they were both facing the toilet at that time. Well, one thing we know for sure is that Mr. Sims did not observe any sexual contact. He didn't observe Mr. Allgood touching the genitalia of his grandson, nor did he observe the grandson touching Mr. Allgood. Didn't see that. So the charge here is attempt. Initially attempted gross sexual imposition and attempted rape. There's no allegation or proof that any sexual conduct or contact actually occurred, but just that this was Allgood's intent to do this, that he wanted to do this, and that having this child in the bathroom was an act to carry out that plan. Allgood said, no, I'm teaching him how to potty train. And then you'll read the record, fight ensued. Not really a fight, a beating. Sims beat Allgood down to the ground, and Allgood couldn't even defend himself. So we're left with those facts, for the most part. And Based on that, the jury convicts him of attempted rape. So the argument was, well, he was attempting to have the child perform fellatio on him. Possibly, there might be a suspicion of that, but there's absolutely no evidence that that was his intent. Mr. Allgood was not making any actions or did not appear in any way to be engaging in any sexual activity. There was no pulling the child. There was no tugging the child. His penis was not erect. None of those things were going on. Everything he said, or I should say everything observed by Mr. Sims was consistent with him doing his potty training. Now they say, the mother and Mr. Sims, the father, both say, well, the child was already potty trained, so that just didn't make any sense to us. But really, when you look at it, 2-year-old child wearing pull-up diapers, potty chair in the bathroom, and it's really what Mr. Allgood's intent is what the question is. Did he think the child needed help in the bathroom? That's entirely reasonable under these circumstances. Again, we see no other activity indicating there was any sexual motive on his part at all. It's very concerning because it's an attempt charge. You got to prove his intent. It's not merely suspicion. I mean, we could all have a suspicion under these circumstances that maybe Mr. Allgood was going to do something if he hadn't been interrupted. But that's not evidence of his intent. And it's not adequate. It's not sufficient. And the court should have granted the motion for acquittal. The Rule 29 motion did not. The other major issue in this particular case has to do with the motion in limine. Now, as I understand it, the trial counsel here had a preliminary hearing at the Lorain Municipal Court, was aware that Mr. Sims, the father, might testify that Allgood had prior sex activity with his daughter. Okay. In fact, a motion in limine was filed, and prosecution was ordered that its witness, Mr. Sims, not testify about any prior bad sexual acts. Clearly required under Evidence Rule 404B and under the Rape Shield Act. I might add that Mr. Allgood was never charged, never convicted of any such crime. Did have a prior record, criminal record, for drug possession, and I think maybe a theft charge, something along those lines, but no sexual convictions whatsoever, no crimes of violence whatsoever. So the defense attorney files a motion in limine, argues the motion in limine, the court grants the motion in limine, the state's aware of that. On cross-examination, defense counsel wants to establish bias because Mr. Sims has a great bias against Mr. Allgood. He doesn't like him, he thinks he's a drunk, he thinks he messes around in his house, and he's asking questions in that regard. That's when, of course, Sims blurts out, well, I don't like Mr. Allgood because he sexually assaulted his daughters. Now, violations of protective orders or violations of motion in limine in this circumstance should have resulted in a mistrial. The evidence was thin. The evidence of conviction was very thin. The prejudice was massive to Mr. Allgood. Now the jury's thinking this guy is a predator. This guy is doing this stuff, and that supports the conviction in this weak evidence case.
In this case, though, the court did give a curative instruction, did it not?
It did. But we feel the curative instruction did not adequately address it, and actually was confusing, and actually resulted, I think, in this jury giving more consideration to the comments made. Essentially, the trial judge said, look, we don't know that this ever happened. There apparently is no criminal conviction for this, and it may not even be true. That's essentially what he told the jury, speaking of these acts. So don't consider it. Well, again, if you read that, based on, and with this thin evidence of conviction, all we have now is a jury pondering, why can't we consider this? What did he do before? And it, again, massively prejudicial, should have resulted in a mistrial. Mr. Allgood is serving a 10-year to life sentence. He has been classified as a Class 3 sex offender based on this evidence. He was found not guilty of attempted gross sexual imposition. There's no way, based on this evidence, a jury can somehow figure, okay, we believe he had the intent to commit rape, but not the intent to commit gross sexual imposition. It's impossible. I realize that Court of Appeals do not regularly reverse convictions under these circumstances, but this evidence is extremely thin. Again, we're talking about an attempt charge. We're talking about intent and whatever acts support that intent. And this case, those acts are equally consistent with potty training this 2-year-old child.
We just over 4 minutes remaining.
All right. I think I will reserve the balance. Thank you.
Thank you.
Just one quick question. Did you
Yes.
make an inconsistent verdict argument?
Yes.
You did. Okay.
It's fine.
Hello again, judges. Just first for the record, Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office. Initially, Judge, the state disagrees that Mr. Allgood made an inconsistent verdict argument. That's not the brief. There's 3 assignments of error: sufficiency, manifest weight, and the court's decision regarding whether to grant a mistrial. There is absolutely no argument regarding an inconsistent verdict. Frankly, the court just issued an opinion on yesterday. So that's why it came to mind pretty quickly. With regard to the sufficiency of evidence argument, judges, what Mr. Allgood asks you to do is to place his argument of potty training as more credible than what the state's witnesses testified. And with regard to a sufficiency of the evidence argument, that's not what the court, this court's authority is. It's not what this court is supposed to do when looking at sufficiency of the evidence. The sufficiency of the evidence looks at what this, you're well aware of it, what the state produced as far as its evidence, and whether it's enough evidence to go to the jury. And when you just run down the evidence, you can bullet point it. First, Mr. Sims hears old school or Allgood, Mr. Allgood, saying to Mr. Sims' 2-year-old son, "Give me a real hug." The house gets quiet. Mr. Sims finds that unusual, so he goes downstairs. He looks in the bathroom, and according to my notes, Judge, his son's face is in front of Mr. Allgood's genitals. Mr. Allgood's holding the little boy with Mr. Allgood's left hand on his neck and shoulder area. The little boy's not wearing a pull-up diaper. And I don't know that the pull-up diaper necessarily leads us to conclude whether this little boy's quote-unquote potty trained or not. Certainly there may be instances, as Ms. Harris testified, so this is part of the record, where her son would wear a pull-up diaper specifically when he was, I believe, napping or sleeping, she said. So he doesn't have his pull-up diaper up. It's not on, according to the testimony. Mr. Allgood's, upon Mr. Mr. Sims showing up in the bathroom, quickly putting his genitals back into his pants with his other hand, his right hand. Excuse me. And Mr. Allgood tells Mr. Sims that he's potty training the little boy. The testimony was that potty training had occurred when this little boy was 1 year old. Both Mr. Sims and this boy's mom, Ms. Harris, testified that this little boy knew how to use his little child's potty, that it was in the corner of the bathroom at that time. According to Mr. Sims's testimony, it wasn't pulled out. So this little boy is not using his potty, which he's potty trained on, and knows how to use.
I know we're gonna read the transcript, and hopefully there's some discussion in the transcript as to whether or not a 1-year-old who can't stand and urinate in a normal-sized toilet, maybe this 2-year-old is tall enough to stand and urinate, and I'd like to, I'm dying to read the transcript to find out potty training. Potty training for a little tiny toilet isn't the same as potty training for a big toilet, for a big boy. So I have a question in my mind, is he showing him how to pee in a toilet, or standing up, or?
I can tell you that the transcript does not, from what I recall, does not indicate that either way. All Mr. Allgood said was he was potty training this little boy.
But when you're talking about what the parents said, where the potty chair was, you're asking us to look at credibility also, aren't you? Which is maybe fine for the second assignment of error, but not the first.
Correct.
Okay.
Which is why, but we're taking these kind of bullet-pointed facts in a light most favorable to the state. So when you look at this potty training element in a light most favorable to the state, it actually militates toward Mr. Allgood not being forthright. That's what it tends to show, because the boy is potty trained. So if he's not potty training the boy, this 2-year-old, then what is he doing in the bathroom with this boy's pull-up down, facing with his face and his genitals?
But isn't that the key question? What is he doing?
Correct. And I think you get that answer circumstantially from the way that Mr. Sims reacted so viscerally. And the jury, I know I'm kind of bouncing back and forth between sufficiency and manifest way, Judge. I'll concede that. But when you just look at the sufficiency, you know, there's a credibility determination that had to be made by ultimately the jury. The judge sitting there, the trial court judge determining, based on the testimony, was there enough to go to the jury? The judge determined there was. You know, there was also this testimony about the toilet having not been flushed. You know, Mr. Allgood's, you know, genitals are still exposed, and he said, well, I just flushed the toilet, but the toilet's not running as if it's been flushed. There's no evidence of any urine in the toilet, according to the testimony. And then you get the one fact that I didn't think anyone really harped on very much, but there was the testimony from Mr. Sims about the little boy saying, "Dada." And Mr. Sims testified that the little boy would use that term, "dada," only when he knew he was doing something wrong, or when he knew he was in a situation he shouldn't have been in, not necessarily of his own doing.
How would he know at age 2 that he was in an attempted rape situation?
I don't have a great answer for that, Judge.
How would he know he was
But-
doing something wrong?
But I think what he knew was he wasn't going to the bathroom.
He was standing in front of a toilet.
Correct. But and this is in my notes here, that the little boy's face is in front of Mr. Allgood's genitals.
All 2-year-olds' heads are right at about people's crotches.
Correct. I mean, I can't debate this.
Yeah.
But what you have here is the wider circumstance, the wider context, all the evidence, not just the one piece, but the boy standing there with his diaper pull up down. His face is in an adult's genitals. He's not using the toilet. No one's using the toilet is what that evidence would tend to indicate. And then the way that Mr. Sims reacted. I mean, he reacts in a way that, and his testimony says, brought back these memories of his mother being sexually abused and molested, and ultimately having at least one child, he testified, by her own father. He asked Ms. Harris to go he tells Ms. Harris, go get me a knife. Ms. Harris believed that Mr. Sims was going to attack Mr. Allgood with that knife. I mean, that's what the jury watched Mr. Sims testify to, and his reactions and his emotions.
Well,
We don't get to see that from that written.
Would you be, I mean, one could argue that he would be projecting his own past on the current situation, and he may not necessarily correlate. But the jury chose to believe that it did correlate.
Correct.
I see.
Yes, Judge. Yes.
Counsel,
what-
since, I'm sorry to interrupt, but
No.
I don't want to speak for my colleagues. I think we get that. But since you're talking about Mr. Sims, jump and talk about what he volunteered.
Yeah, Judge, and I was going to that next anyway. But
I knew that.
to those eight words that he said he got sexual assaults towards his own daughter.
What exactly, if you know, and I know it's hard when you weren't, I assume you weren't trial counsel.
I was not.
What exactly was the motion in limine? What was asked to be limited and what was granted to?
I'm not sure.
So we'll need to see that. Okay, thank you.
Yeah, frankly, I'm not sure. And frankly, I'm not sure what occurred at the preliminary hearing exactly. But what I am sure of, Judge, is that the question that was asked by defense counsel, there was the lead-in was, he asked him, so you're pissed that Allgood's at your house, right? Yes. Now that's a leading question. You're pissed he's at the house? Yes. Then he says, is that because my client doesn't think you're good for his daughter? Now that calls for a yes-no answer, but that's not a leading question. It calls for a yes-no answer, but that's distinguished from a leading question. It doesn't call for an answer. And frankly, under different circumstances, with the right trial court judge, that opened the door if the prosecutor wanted to, but I think judging from the record, he got the idea he better not. But there's a great argument to be made that defense counsel opened the door to say, well, my client doesn't think you're good for his daughter. Is that because you're pissed? Well, why are you pissed then?
But the trial court judge, and I'm reading here, and I'm quoting the judge, so my perception is that the question did not solicit the answer, nor do I think the state either solicited or allowed, but properly instructed the witness. I've got a situation where the witness ignored the instructions of the state and went beyond the parameters of the question. That's what the trial court judge said.
Correct. But if you look at another part of that, there's a part where the trial court judge said, basically what I just said is that you asked a yes/no question, but defense counsel, it wasn't very exact.
Well, counsel's hashing it out. I mean, trial court judge is hashing it out, but ultimately, that's what the judge concludes.
Correct.
And then says, I'm going to try to rectify that prejudice. I'm not saying I'm completely comfortable that that's sufficient.
Mm-hmm. So
clearly, the trial court judge was concerned about what Mr. Sims said.
Yes. And I think everyone would recognize
Did the
there
judge
would be
rectify it?
concern. Well, and there is the curative instructions were confusing, but what the trial court said is there's no evidence that Mr. Allgood had a prior criminal record, and the jury should presume nobody has a criminal record until someone testifies otherwise. I don't know how much clearer you can make it to a jury. And what's kind of strange, bizarre, is during appellant's presentation, he brought up his criminal record to you. Drug offenses, theft, that's not part of the record here.
Well, this
The rec-
motion in limine was a 404. Does it have to be a criminal record? Doesn't have to be a conviction, does it?
No, absolutely not. No, other acts evidence.
Because if I'm a juror, I might be thinking, yeah, the guy didn't get caught or nobody came forward, but
Certainly,
as opposing counsel said, he must be a predator.
but what you had here was 8 words that the trial court judge determined the proper way to proceed at his discretion, and that's what you're looking at, was it an abuse of discretion, is to issue this curative instruction. He tells him, don't raise, he speaks directly to the witness saying, don't raise anybody's criminal record unless you're specifically asked to. And says to the jury, nobody has, he essentially says, nobody has a criminal record. That's what you should know. And we do assert that this is basically invited error. I mean, he, as I said, he asked him, well, basically, why don't you like him? It wasn't a question of, you're aware Mr. Allgood doesn't think you're good enough for his daughter, correct? I mean, that would have been a leading question that called for a direct answer, yes or no.
And if that's your own time.
Judge, if I could, we just ask that you affirm those convictions and that there was no abuse of discretion. Thank you, Judge.
Thank you. You have just over 4 minutes. So.
Thank you. I did want to go back to the inconsistent verdict argument. Correct, it's not made in the brief. However, it was raised at the trial court level as part of the motion for acquittal. And further, page 10 of the brief, I go into some detail about how the evidence in this particular case is not sufficient for attempted rape. And if the jury felt there was some sexual intent on his part, it would be speculation to think it would be attempted rape rather than attempted gross sexual imposition. Several cases have been cited about that in this brief. When you get into these intent issues, even if there is evidence of some sexual activity, very hard to distinguish between attempted rape and attempted gross sexual imposition. The 404B motion in limine went to any prior bad conduct. It didn't include just criminal convictions. And quite frankly, the judge's curative instruction created a huge problem that was never really fixed by his second instruction. What he went on to say was there's no evidence of the jury's instructed to disregard this testimony with regard to any other prior alleged sexual assault. It is not admissible in this particular case, and at least according to the records exchanged between the parties, may in fact not be accurate or truthful. It should have just been told to disregard, not to allow speculation that it might be truthful, there might be something to it that was not exchanged in records and so forth. And again, very thin evidence here, Your Honors. So I think that particular instruction contributed to the conviction in this case. And it certainly did not cure the motion in limine violation and the admission of those prior bad act statements or statements of Mr. Sims. Thank you very much.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and on the Supreme Court. Thank you, gentlemen.